The Gartland Group presents Taxes, the IRS, and You with your host, Bernie Gartland. Taxes, the IRS, and You is a different kind of show that'll help you solve your tax problems. As former Deputy Attorney General of the state of Delaware and with over 25 years of experience as sole practitioner in both Delaware and California, the name Bernie Gartland has become synonymous with taxes. And now your host, Bernie Gartland.
Hi everybody, Bernie Gartland. Name of the program is Taxes, the IRS, and You, and we're here every Wednesday to talk about tax issues. And sometimes we have certain other aspects of concepts that you never heard of. Now, we know that we talk to you every week on tax problem solving, tax bankruptcy. We talk about what Kathy Griffin can do with, Kathy Satter can do with Griffin bookkeeping. We talk about what Brian can do with the tax preparation and audit. And from time to time, we run into something that is so explosive that we take the time to utilize the show to inform you of stuff that the normal practitioners out there, whether they're bankruptcy practitioners or certified financial planners or CPAs, don't really have a handle on. The subject that we're going to talk about today is so intense and so explosive that I would suggest to you, if you haven't hit the button to record this program on your DVD or TiVo, make sure you do, and make sure your CPA and your financial planner get to look at it, because we are going to talk about something that has happened a few years ago that nobody understood, nobody believed it was happening, and yet it was happening and is happening. And we're going to bring you up to date on what we talked to you about some time ago. But there's a lot of update. There's a lot of things going on that are of monumental consequence. So with me today is one of our advisors here at Gartland Group. Remember, Gartland Group consists of three different entities: the law firm, the Griffin Bookkeeping with Kathy Satter, and also with American Tax Centers. But part and parcel of our estate planning and our asset protection, and Tim Berry, who is probably one of the best tax attorneys across the United States. He and I used to give lectures across the United States until I got tired of spending my weekends in airports. But he's here to bring you up to date on something that was discovered by a Department of Labor ruling that we found out about because Tim and I handled a tax court case that concerned an IRA that 5 investigators from the IRS wanted it to be blown up and distributed for tax purposes. And it was a lot of money involved in that IRA. Tim and I represented the client, and we were successful. Remember, we had 5 different lawyers and agents against us, and we prevailed. And then we uncovered something during that research. I should say more precisely, Tim uncovered it during the research, and Department of Labor ruled on something he's going to talk to you about that has catastrophic consequences at the time. So first of all, Tim, you're here. Tell the folks, I mean, you've been here before.
Sure.
And tell the folks a little bit about yourself so they know your credentials and credibility, so that we can go into this Department of Labor ruling.
Credentials and credibility. Well, folks, I'm an attorney. I've been dealing with issues regarding retirement plans, regarding trusts for years now. And it's lots of fun going through this stuff and doing the research and finding the little nuggets of gold, if you will. And then you also find some little nuggets as you go through this stuff that it's not quite gold, because it has some really dramatic effects. And unfortunately, those effects can be incredibly negative for a lot of people. And that's what we kind of discovered working with that tax court case, right, was this one little nugget, and it could either be gold or it could be ungold, for lack of a better phrase, due to the ramifications of this nugget. It's just astounding.
Right. And the other thing that and it happened the other day when I called a very high-level official with the United States government in Washington, D.C.
Yep.
to talk about this issue, and we were on the phone for about 45 minutes, and this is a person who also used to be an attorney with the Security and Exchange Commission, And we were talking about this issue when he just did not understand it until so I said, let me ask you a question so I can get a frame of reference. If there has to be a government agency that controls what you can or cannot do with an IRA, I asked this person, this high-level person, Washington, D.C. in the government, what federal agency has the power, the authority to tell you what you can or cannot do with your IRA? And he said, well, the Department of Treasury. And I didn't know what to say because it's not the Department of Treasury. Tell the folks who it is and what the DOL ruling is.
Well, the power to control your retirement plan assets is split between two government agencies. And that's part of the reason for the problem of what we're going to be talking about today is it's split between the two government agencies, and they really don't talk to each other all that much. That's the feeling I get. But Department of Labor is in charge of interpreting this one particular code section, and then you got the good old IRS, Department of Treasury, in charge of enforcing this provision.
Right.
And yet, once again, it seems like these two, they're married, because they certainly don't talk to each other. That was a joke there, Bernie.
I got it.
Okay.
Folks, you got it too.
Sorry.
Yeah. So and again, it's just like the legislative body of the state of California creates the traffic laws.
Yep.
The Highway Patrol enforces it.
Yep.
Okay. It's the same thing. If you had taught me this, the 1978 Tax Reform Act, everything was transferred to the Department of Labor to tell you what you can or cannot do with your IRA. Once they make a determination, the enforcement body is the Department of Treasury, IRS. Okay, so tell me what the Department of Labor ruling was.
Here's what the labor ruling was, and it's really a very basic concept, but once again, few people are really aware of the IRA rules. And here's what the ruling was. The ruling said, if an IRA owner engages in any extension of credit between the IRA and the IRA owner, your IRA is blown up. Now, I use the fancy lawyerly phrase, legal phrase of extension of credit. Let's boil it down for you guys to understand exactly what we're talking about. What we're talking about is the Department of Labor said, if you sign an account form for your IRA, and on that account form, it has the word guarantee, or you agree to pay any debt incurred by the IRA, or, and this is a word you want to look through all your agreements for, you agree to indemnify the brokerage firm for any liabilities of the IRA. That's an extension of credit. If you have done that, if you have signed that paperwork, you have caused your IRA to be completely blown up. And what do I mean by completely blown up? What I mean is that is now fully subject to taxation from a bankruptcy viewpoint. It doesn't have creditor protection. It is blown up. It's not an IRA anymore. It's just a regular savings account. So all of those years you had that you thought of tax deferral, there's no more tax deferral on that account. Any tax deductions you took on that money, the IRS could come back and say, no, you owe a bunch of taxes because that blew up as soon as you signed that brokerage agreement. So once again, very simple. If whenever you review the brokerage agreement of your IRA and it says that you will be liable for any losses in the IRA, you agree to indemnify the brokerage firm for the IRA, you've probably blown up your IRA. That's what the
and at the time it's
says.
Blown up, what it means is that it never existed as an IRA, so therefore it's taxable from the get-go of when you sign. In fact, one court said, quote, as incredulous as it seems, the mere fact that you signed the application made it a distribution.
The mere act of signing the application caused the IRA to be completely and fully distributed, fully taxable.
Right.
Taxpayer is now liable for back taxes, penalties, and interest.
Right.
Oh, and the gravy on the cake?
Hold on a minute. We're going to come right back and we're going to tell you what the gravy on the cake is. Democrats and Republicans in Washington both agree the immigration system is broken and needs to be fixed. Hi, I'm Bernie Gartland with the Gartland Group.
And I'm Karen Clare. The new legislation requires clients to be represented in a very different fashion.
And we at Gartland Law are fully aware of those changes and have the expertise you need for any problem.
If you have any questions about the new immigration benefits, call today for a free and confidential consultation.
At Gartland Law, we can help. Hey everybody, Bernie Gartland. The name of the program is Taxes, the IRS and You, and Timothy Berry is here today. He is a tax attorney extraordinaire, And he is also talking to you about gravy on the cake. Now, the gravy on the cake relates to the Department of Labor ruling that your IRA may not be an IRA. If there is certain language in the application that the broker gives you, the Department of Labor has issued a ruling saying it's not an IRA. So just before the break, you were going to talk about the bigness of it all. What is it?
Well, the bigness of it all, and we already touched upon it, is these accounts are deemed distributed, no longer IRA accounts. So we have a tax disaster, first off. Then, secondly, your firm works with taxes, and you also do a lot of what other sort of work?
Tax problem solving.
And bankruptcy.
And bankruptcy and audits.
And audits. So now, if your IRA's been deemed distributed,
right,
and you file bankruptcy, and you weren't aware that the account's been deemed distributed, your IRA, as a general rule of thumb, is exempt. Whenever you file bankruptcy, you're allowed to go through bankruptcy and come out of bankruptcy with that IRA, and you can use that to maybe get going on your life again. But if it's deemed distributed due to you violated this code section, the trustee takes away that IRA. And trustees have been taking away that IRA. So a lot of people think, well, gosh, this is bad from a tax viewpoint, but I'll pay it whenever they catch me. And now I'm saying, well, gosh, if you ever have any creditor issues, your creditors can take away that account that you thought was an IRA. And then even going a little bit further, some people say, oh, I'm not really worried about the tax ramifications. I don't have creditor issues. Let's talk about estate planning. A lot of people are saying, my family shall receive my IRA, and my second spouse, third spouse shall receive my other assets. Now, if that second spouse, third spouse can show that that is no longer an IRA, the family gets zilch, and that second, third spouse gets everything. So there's so many ramifications here. We got tax ramifications. We've got bankruptcy ramifications. We got estate planning ramifications. It's just astounding what's happening. And Medicare and Medi-Cal too, same thing.
And here's something that perplexes me, and that's one of the reasons why we're having this program today, to give an update, because there's more to it.
Oh, a lot more.
It may end up to be a Supreme Court of the United States issue. We'll go into that in a minute. But I have this thing about me that it's a social worker syndrome, because I was a social worker before I became a lawyer. Mm-hmm. I like to share my knowledge with the professionals, the CPAs, the bankruptcy attorneys, the certified financial planners. And we talk to them about it, and they say, the financial planners say, well, first of all, have them say, I don't believe it. And the second, I say, well, go to the ruling. I mean, it's there and it's happening. And they say, well, my clients don't go into bankruptcy. All I do is put them in IRAs for estate planning. And I'm sitting there and going, the light didn't go on. If in fact you don't worry about bankruptcy, you don't worry about the trustees going after, what about when your client passes on and all of a sudden you have all these folks saying, okay, well, wait a minute, Mom gets a $2 million IRA. Who's it with? Oh, they have the bad language in there, and they say it's not an IRA. So how do you, as a certified financial planner, feel about that concept that you have just created, and you had knowledge? You had knowledge. And some of the big, by the way, I recently went to one of the brokers and I got their application, because I was trying to give him information. Really didn't understand it, and right in the application was the applicant indemnifies the broker in two different areas. I showed you where that was on page 7 and another page, and then they say, well, we have an arbitration clause in here that overrules all that. What does an arbitration rule do in an application?
It has no bearing on that whatsoever, but what you're talking about, Bernie, I cannot overemphasize how much money have people lost, and I'm just going to be blunt about it. I wasn't a social worker, so I'm just going to be blunt.
Right.
How much money have people lost due to the stupidity of their advisors?
Right.
And I'm not just knocking financial advisors, I'm knocking many times CPAs, brethren attorneys. There's a lot of them out there who aren't aware of the rules, and they intentionally, I think, try to stay woefully ignorant of the rules, and yet they give this advice. They let people think that they are knowledgeable in it, and they just give faulty advice. The financial planners, I mean, this one's a real disaster. This has been getting out. This has been written up in Financial Planning magazine, so financial planners should be aware of this problem, this dilemma. But here's the big challenge. Let's say I've got a $100,000 account that I thought was an IRA, and I blew up that account by just agreeing to the brokerage account language inside there. It's no longer an IRA, it's fully taxable, but emphasis, it's no longer an IRA. Now I go to this wonderful person, this financial planner who knows everything about everything, and they're supposed to know about this issue, but they really don't, and they have you roll your funds over into a new account, and they make it an IRA account.
Right.
Well, contribution limits for an IRA are $5,000, $6,000. So if I moved $100,000 into a brand new IRA account, and of that only $5,000 or $6,000 qualifies as a true IRA, I have made something called an excess contribution, and the penalty for making those excess contributions, 6% penalty tax each and every year. So that's roughly another $6,000 a year we're racking up in penalties on other stuff.
But you know, there's an opposite angle to this. Suppose somebody had an IRA in an IRA account that didn't have the bad language, and some financial planner said, I want you to convert that or roll that over to this IRA, and it has the bad language. And the bad language is the guarantee, the surety, the indemnification. And I will tell the folks out there, this is something I really want to go into because you and I talked about this earlier. Many, many, many times, folks, when I talk to our clients about this, because I want to protect them, I say, go get the application that you have from the broker, and I will take a look at it. Tim and I will take a look at it, and we'll see if there's any bad language in there. Tim, we never get the proper forms. And that's what's happening to the people. They say, well, here's what they gave me. Tell the folks about what they should be looking for.
Yeah, there's a number of forms. Whenever you're dealing with an IRA, you have the custodial agreement, you have the disclosure agreement, but the really bad language is typically inside the brokerage agreement. And whenever you sign at the bottom, it says, I certify that I've read the arbitration provisions in a particular brochure of theirs. Make sure you ask for that brochure or the form that has the arbitration language, because that's whenever it has the really mean, nasty language saying that you agree to be liable for the IRA's debt. So if you want us to review your forms, and you really need to have these things reviewed, make sure that you provide us with the form that has the arbitration language between you and the brokerage firm.
Yeah, and that's very interesting, because remember something is that that if that language is in there, you do not have an IRA, and there's all kinds of ramifications. And the bankruptcy court's trustees are taking IRAs away. In fact, and I can say this because it's absolutely true. There's a case out of Tennessee that the IRA was a Merrill Lynch IRA, because the folks are saying, well, wait a minute, it must be some rinky-dink thing. So when we get back, I'm going to tell you about what happened to $64,634 and where that case is now, that it's going to become major, major law to the detriment. And by the way, the IRS has already recognized. The Department of Labor has made a ruling. The IRS has already accepted that ruling and has some language to say that they think will help you, but it's our position that it's not really going to help. So when we come back from our crash commercials, self-promoting commercials, I take no problem with, we're going to talk about announcement number 2011-81 from the Internal Revenue Service that says there has to be a class exemption from the Department of Labor. And guess what? The Department of Labor hasn't done it yet. And even if you have that class exemption, it may not apply in bankruptcy court. We'll be right back. Hi folks, I'm Bernie Gartland, and I'm so proud to introduce you to the Gartland Group. Do you have a need to have your current or prior year tax returns prepared? Is the IRS knocking at your door and you need legal representation? Do you need professional bookkeeping services? The Gartland Group can help. Let us put control back in your life and have that control give you a future.
Call today for a free consultation.
Hi, I'm Al Geiberger. As Mr. 59, I can teach you how to get out of trouble on the golf course. But when it comes to trouble with the IRS, I can't teach you a thing. That's why I went to someone I knew I could trust, Bernie Gartland and the Gartland Group. After seeing how they solved my IRS problems and handled my tax preparations, here's my tip from Mr. 59. Don't take your tax returns to anyone else.
Hey everybody, Bernie Gartland. Welcome back to Taxes, the IRS, and You. We're talking about blown up IRAs today. What a subject that is, blown up IRAs. And maybe we haven't covered all the aspects because we got limited time here, but I want to impress upon you that this is a major problem going across the United States now for the last 4 years, even though a lot of the CPAs and financial planners do not believe it. But all they have to do is check the Sixth Circuit, okay? Merrill Lynch has an IRA with a gentleman, a debtor. The debtor files a bankruptcy in Tennessee. The trustee and the trustee attorney in that bankruptcy says, you know what? I think I know about this Department of Labor ruling. And so when we go to a meeting of the creditors, it's called a 341A hearing, I want to ask the debtor's attorney some questions. And so the trustee's attorney sits there with the trustee and says, Mr. Debtor's attorney, I see you exempt out under the IRA exemption in bankruptcy court, $64,000, I think it was $464 or something like that. And the debtor's attorney says, yes, that's right, because it's an IRA and it's exempt under the code. And he says, well, would you mind providing me with the Merrill Lynch application that established the IRA? Not to worry, not to worry. Boy, it was like a sheep going to slaughter in that case.
Yeah.
And what happens is right there in Merrill Lynch application is the language that the Department of Labor says is bad. And so the trustee says to the court, they do a memorandum of law. It was a long, drawn-out process, and the court says, yeah. And that's where the court said, as incongruous as it may seem, the mere fact that you signed the application made it blown up, defective, not existent. They turned over to the trustee for distribution. It was appealed to the bankruptcy appellate court. It was affirmed. In other words, the bankruptcy appellate court said, well, the judge made the right decision. It was then appealed to district court, and the district court judge said, well, they made the right decision. This was not an IRA. Merrill Lynch, it was not an IRA. Now it's at the Sixth Circuit. I've read the briefs, and I got to tell you something, that trustee's attorney is right on point to the detriment of the client. Now the problem is,
Bernie, let me just interject real fast here. Here's the amazing thing about, you've read the briefs and everything. You would think that if Merrill Lynch had this problem and one judge has deemed it a problem, a second judge has deemed it a problem, a third judge has deemed it a problem, you would think that Merrill Lynch would be kind enough to hop into the fray and say, no, our documents are valid documents, they're good documents. Bad news, Merrill Lynch hasn't done a single thing. There is some lobbyist group that's popped in on behalf of that, but Merrill Lynch themselves, who have the bad language inside their application, hasn't done a thing. They left that person just drifting in the wind.
Right, and then there's other firms on equal level as Merrill Lynch that have bad language also.
Yeah, and I'm probably jumping ahead a little bit here, but there's that one trustee or an attorney for the trustee. She's gone out and she's subpoenaed probably a dozen at least firms to get their language, and is going after debtors. I think she's been successful 2 or 3 times already. This is, to quote Tom Clancy, a clear and present danger.
Right. Well, you know what the interesting thing about it is?
Yeah.
The interesting thing about it is that from all that I've read that you provided for me reading is that the brokerage are making deals with the trustee.
They're settling out.
They're settling out because they know they have defective language. And ladies and gentlemen, it's not only Merrill Lynch, it's some very, very high-level firms that have the same bad language. In fact, one of them sent out a brochure to like 7 million of their clients indicating why their application was defective. And the funniest thing is, they never changed the wording of the application. This is unbelievable to me that there are going to be major lawsuits in the future for, especially if you know that something is wrong and illegal and you do not cure it, then you can be held responsible. But I think the arrogancy of these brokerage firms is so great that they don't think anything's going to happen.
And Bernie, let me go a little bit further also on some other stuff. Once again, I wasn't a social worker. So I've actually been involved in the cases where the bankruptcy attorneys have hired me to point out the errors in people's IRAs. And we've been successful on every single one so far. Every single one, we've recovered assets from the person's account that they thought was an IRA. This is happening.
And that's what's happening, is that the major brokerage firms, including Merrill Lynch, hasn't done anything to rectify the situation. And I think the more that people are getting hurt, unfortunately, that it's going to, somewhere going to say, we got to stop this. Now, explain to the folks what announcement 2011-81 from the IRS says.
Got it. Well, we talked about before the relationship between the Department of Labor and the IRS is pretty much like a marriage. They don't communicate.
Right.
Department of Labor supposedly is going to be granting an exemption sometime, and we don't know what that language is going to be, how far.
For tax purposes.
For tax purposes. We don't know how broad it's going to be. IRS has already come out and they've said, hey, we're aware of this bad language, but at the present time, we're not going to take any steps from a tax viewpoint to enforce that. Now, here's a very interesting thing, Bernie, and I don't know if I can go into it. Should I go into what I got in trouble for, and should we bring this up?
Sure, go ahead.
Our friends at the IRS...
We have 2 minutes left.
Okay, well, I'll be very short and succinct with this. The good friends at the IRS told me I was a bad guy for telling people about these distributed IRAs, and get this, you may not owe taxes on your IRA, because if you engaged in this bad stuff a long time ago, statute of limitations is run. Now the IRS, with this announcement, has pretty much shot themselves in the foot.
Right.
And they've said, we're aware of this problem, but you know what? We're not going to do anything right now. Right. They have no fence against the statute of limitations, so some people, if they have substantial IRAs, it might make sense at this point to say, hey, IRS, you were aware of this problem. You did nothing on this problem. We don't believe we owe any taxes on this because you've waived your right to collect taxes on it. So that's another aspect of this.
Here's the other problem that we do some thinking. The Internal Revenue Service, under announcement, accepted the fact that DOL made the right decision. And they're saying, but we want DOL, Department of Labor, to issue a class exemption for tax purposes, okay?
Yeah.
The problem is, it's still defective under the ruling. It may not be taxable by the IRS anymore, but it's still defective. So it doesn't cure the problem with trustees in bankruptcy.
Yep.
So,
or estate planning.
And for estate planning. We were going to cover a lot of remedies, because there are remedies under 4975B, I think, and some letter rulings in some other areas. But I think that we need to talk about that at a different time. And by the way, if anybody email me at bernie@gartlandgroup.com, ask me questions about their IRAs, Tim and I will talk to you. We'll call you on the phone, or we'll respond to your email, and we'll tell you what the remedies are if you have a blown up IRA. Make sure you get your brokerage agreement to see if the defective language is in there. Because if it's in there, you may have a problem for creditors, and even if you don't go in bankruptcy, for estate planning, you may have a taxable issue. So we'll see you next week. The name of the program is Taxes, the IRS, and You.